The Manhattan District Attorney's decision addresses an emotional heightening of the request, and possibly sets the case on a way toward criminal accusations against the former president. The Manhattan District Attorney's Office on Monday will start introducing proof to a fabulous jury about Donald J. Trump's role in paying quiet cash to a pornography star during his 2016 presidential campaign, laying the basis for likely criminal accusations against the former president before long, as per individuals with information regarding this situation. The grand jury was as of late impaneled, and witness declaration will before long start, an unmistakable sign that the district attorney, Alvin L. Bragg, is approaching a choice about whether to charge Mr. Trump. On Monday, one of the observers was seen with his legal counselor entering the building in Lower Manhattan where the grand jury is sitting. The observer, David Pecker, is the previous publisher of the National Enquirer, the newspaper that assisted intermediary the arrangement with the pornography star, Blustery Daniels. As examiners get ready to recreate the occasions encompassing the payment for grand jurors, they have looked to meet with a few observers, including the newspaper's former editor, Dylan Howard, and 2 workers at Mr. Trump's organization, individuals said. Mr. Howard and the Trump Organization workers, Jeffrey McConney and Deborah Tarasoff, have not yet affirmed before the grand jury. The examiners have likewise started reaching authorities from Mr. Trump's 2016 campaign, one individual said. What's more, in a sign that they need to prove this observer's accounts, the prosecutor as of late summoned telephone records and different reports that could reveal insight into the episode. A conviction is certainly not a slam dunk, to a limited extent in light of the fact that a case could depend on showing that Mr. Trump and his organization misrepresented records to stow away the payout from citizens days before the 2016 political race, a low-level crime accusation that would be founded on a generally untested lawful hypothesis. The case would likewise depend on the declaration of Michael D. Cohen, Mr. Trump's previous fixer who made the payment and whom himself confessed to federal charges connected with the quiet cash in 2018. In any case, the developments compound Mr. Trump's mounting legal woes as he faces an array of law enforcement investigations. A district attorney in Georgia could look to prosecute him for his endeavors to upset his 2020 political race misfortune in the state, and he faces a unique guidance examination concerning his expulsion of delicate reports from the White House. Mr. Bragg's choice to impanel a grand jury zeroed in on the quiet cash, supercharging the longest-running criminal examination concerning Mr. Trump, addresses an emotional heightening in a request that once seemed to have arrived at an impasse. Under Mr. Bragg's ancestor, Cyrus R. Vance Jr., the lead prosecutor's office had started introducing proof to a prior terrific jury about a case zeroed in on the quiet cash as well as on Mr. Trump's more extensive strategic policies, including whether he deceitfully expanded the worth of his real estate to get ideal credits and other monetary advantages. However, in the early long stretches of his residency last year, Mr. Bragg created worries about the strength of that case and chose to leave the grand jury show, provoking the renunciations of the 2 senior prosecutors driving the investigation. One of them, Mark F. Pomerantz, was exceptionally condemning Mr. Bragg's decision and has composed a book that is planned to be distributed 1 week from now, People vs. Donald Trump, itemizing his record of the request. Mr. Bragg's office as of late kept in touch with Mr. Pomerantz's publisher, Simon & Schuster, communicating worry that the book could reveal grand jury data or disrupt the investigation. As far as it matters for him, Mr. Trump has denied all bad behavior and chalked up the examination, as he has oftentimes previously, to a partisan witch chase against him. In the event that he was at last indicted, Mr. Trump would confront a most extreme sentence of 4 years, however, jail time wouldn't be compulsory. A representative from Mr. Bragg's office declined to remark. Mr. Pecker's legal counselor, Elkin Abramovitz, didn't quickly answer a solicitation for input. A legal counselor for Mr. Trump, Ronald P. Fischetti, declined to remark, as did a legal counselor for Mr. McConney and Ms. Tarasoff. The panel hearing proof about the quiet cash reasonable known as an exceptional grand jury. Like customary grand juries, it is comprised of 23 Manhattan inhabitants picked aimlessly. Yet, its individuals are confirmed to serve so that a half-year might be able to hear complex cases, as opposed to the normal 30-day panels that survey proof and decision on whether to get charges instances of thievery, attack, burglary, murder, and different wrongdoings. The district attorney's investigation, which has unfurled in fits and begins once again in the most recent 4 years, started with an assessment of the quiet cash bargain prior to growing to incorporate Mr. Trump's property valuations. The previous summer, Mr. Bragg's prosecutors, working with the Office of New York Attorney General Letitia James, got back to the quiet cash over again, looking to kick off the request after the takeoffs of Mr. Pomerantz and Carrie R. Dunn, the other senior prosecutor in the investigation. The district attorney's office is likewise proceeding to examine the way that the former president esteemed his resources, individuals with information regarding this situation said. Throughout the span of the extensive investigation into Mr. Trump and the conduct of his business, the quiet cash request re-emerged inside the head prosecutor's office with such routineness as of late that prosecutor came to allude to it as the zombie theory, a thought that actually won't pass on. The principal noticeable indication of progress for Mr. Bragg came for the current month when Mr. Cohen showed up at the lead prosecutor's office in Lower Manhattan to meet with examiners without precedent for over a year. Presently, he is supposed to return for no less than one extra meeting with the prosecutors in February, one individual said. The legal advisor who addressed Ms. Daniels in the quiet cash bargain, Keith Davidson, is additionally expected to meet with the prosecutor before long. Mr. Trump's organization was instrumental in the arrangement, court records from Mr. Cohen's government case show. Despite the fact that Mr. McConney and Ms. Tarasoff were not key members, they sorted out for the Trump organization to repay Mr. Cohen for the $130,000 he paid Ms. Daniels, whose genuine name is Stephanie Clifford. Alan H. Weisselberg, the organization's former CFO, was additionally engaged with repaying Mr. Cohen. What's more, as per Mr. Cohen, Mr. Weisselberg was engaged in a conversation with Mr. Trump about whether to pay Ms. Daniels. Mr. Weisselberg is at present spending time in jail in the Rikers Island prison complex in the wake of conceding to an expense misrepresentation plot irrelevant to the quiet cash bargain, a case that likewise prompted the conviction of the Trump organization in December. In spite of the fact that he was the star observer for the district attorney's office, all things considered, affirming against the organization that had utilized him for a really long time, he has never embroiled Mr. Trump in any bad behavior. Without his collaboration, prosecutors could battle to connect Mr. Trump straightforwardly to the unfortunate behavior. In 2018, when Mr. Cohen pleaded guilty to federal campaign finance charges originating from his part in the quiet cash installments, he blamed Mr. Trump, saying the payout was finished, collaborating with, and at the course of, the president. Federal prosecutors concurred that Mr. Trump was behind the arrangement, however never charged him or his organization with wrongdoing. Except if Mr. Weisselberg consents to participate, proving Mr. Cohen's record could introduce a test for examiners. Mr. Trump's legal counselors will probably contend that Mr. Cohen, an indicted criminal who confessed to misleading government authorities, has an issue against Mr. Trump. In any case, there is some fortuitous proof recommending that Mr. Trump was associated with the arrangement. Mr. Cohen and Mr. Trump talked by telephone 2 times the day preceding Mr. Cohen wired the installment to Ms. Daniels' legal counselor, as per court records in the government case. For Mr. Bragg's examiners, the center of any conceivable case is the manner by which the Trump organization repaid Mr. Cohen for the $130,000 he paid Ms. Daniels and how the organization recorded that payment inside. As per court papers in Mr. Cohen's federal case, the organization dishonestly distinguished the repayments as lawful costs. The district attorney's office currently gives off an impression of zeroing in on whether mistakenly ordering the payments to Mr. Cohen as a legitimate cost crossed paths with a New York regulation that restricts the misrepresenting of business records. Infringement of that regulation can be charged as a wrongdoing. To make it a lawful offense, Mr. Bragg's examiners would have to show that Mr. Trump misrepresented the records to help carry out or disguise a second wrongdoing in what examiners would contend was an infringement of a New York State political race regulation. That subsequent viewpoint has generally gone untested, and would thusly make for a hazardous legitimate body of evidence against the former president. Mr. Pecker's declaration could support the indictment's contention, in any case. As a long-lasting partner of Mr. Trump, the publisher concurred during the 2016 campaign to be keeping watch for possibly harming tales about Mr. Trump. That October, Ms. Daniels' representative and legal counselor examined the chance of offering selective privileges to her story to the National Enquirer, which would then never distribute it, a training known as catch and kill. Be that as it may, Mr. Pecker, who 2 months sooner had burned through $150,000 to purchase and kill a former Playboy model's account of an issue with Mr. Trump, wouldn't make a payment to Ms. Daniels also. He and the tabloid's editor, Mr. Howard, concurred that Mr. Cohen would need to manage Ms. Daniels' group directly. At the point when Mr. Cohen was delayed to pay, Mr. Howard squeezed him to finish the arrangement, in case Ms. Daniels open up to the world about their conversations about stifling her story. "We need to arrange something," Mr. Howard messaged Mr. Cohen in late October 2016, "or it could look outrageously terrible for everybody." After 2 days, Mr. Cohen moved the $130,000 to a record held by Ms. Daniels' lawyer. Please, if you love our video, Give us a thumbs up, the like button, turn on the notification bell, and subscribe so that you won't miss the next video when we upload.